Okay, take two. Welcome, everybody, to our second PPE constitutional conversation this year. I am, as most of you know, Professor Geoffrey Sigalet, an assistant professor of political science here at UBCO. And welcome, everybody. And I'm also the director of the UBC Research Group on Constitutional Law. It's my very great pleasure to introduce our guest today, Chief Justice Glenn Joyal of the Manitoba Court of King's Bench. Justice Joyal is originally a Franco-Manitoban. He grew up in Winnipeg. He came out here to BC to pursue his undergraduate studies at Simon Fraser University in 1983. He received his undergraduate degree in 1983. He received an MA from the University of Manitoba in 1992. He completed his Bachelor of Laws at McGill University in 1986, and then pursued graduate studies in public law and political theory at Oxford University from 1995 to 1996. At Oxford, he studied with some of the great legal philosophers that some of you have read in courses, with Professor Irvin and myself, Joseph Raz and John Finnis and Ronald Dworkin. During his European sojourn, he became fluent in Italian somehow. And so I find that particularly impressive as a biographical fact. And he's been a member of the Manitoba Bar since 1987, the year I was born, and has practiced as a provincial Crown Attorney from 1986 to 1990. And then he worked with Justice Canada as an attorney from 1990 to 1997, where he did some very famous cases, including the Sauvé case, Sauvé 2 case, which we'll probably discuss, where he was the Crown's attorney in that high-profile charter litigation. And then he worked with the firm Wolch Pinx Tapper Scurfield in Winnipeg from 1997 to 1998. He was appointed Chief Justice of the Court of King's Bench in 2011. And continues to contribute to public legal debates from the bench, and including visits like the one today. So please join me in giving a very warm UBCO welcome to our guest. So I thought we'd structure today as a fireside chat, which we've done before at these events, and that hopefully involves less of me speaking and more of our guests speaking, and so let me know if I'm talking too much. And then after some back and forth, I thought we would then open it up to questions from all of you, which we will probably stop recording at for your own, good. And for Justice Joyal.
Not worried about me.
Exactly. So I thought we'd start off by asking a question, a kind of conceptual question, which is that in a lot of your in your public engagement and your writing, you often talk about judicial supremacy and problems relating to juristocracy, the idea of courts becoming getting out of their lane and becoming too dominant in constitutional dialogues with legislatures. And I thought I'd just ask you to open up with some thoughts on that idea of what is judicial supremacy and what are some alternatives to it?
Well, I think I try to be hopefully a bit more nuanced on the subject because it's a complicated subject. As a member of the judiciary, I don't want to diss my colleagues who I think are people of really good faith, and sometimes we have different points of view on constitutional interpretation of the courts, but generally speaking, we're all common ground. But rather than talk about judicial supremacy, what I've talked about often is balance between important institutions. I believe you need a strong judicial branch. The Charter requires it. Section 52 requires it. We want a charter, or a judiciary that will be a guardian of the Constitution, but you also want a very strong, vibrant legislative and executive branch that will purposefully themselves engage in the life of the Constitution outside of the courts in ways that promote and protect rights in ways that we don't typically think are necessarily within the ambit of politicians. And I think that's a misapprehension of what politics and what the legislative and executive branches can do. So rather than talk about judicial supremacy, I've tried to talk about balance, this balance between the two branches. And I think sometimes there has been a bit of an imbalance, and I'm not blaming the judiciary. Sometimes they've certainly overreached. They've used interpretive approaches now that have congealed and sort of developed and will be difficult to change. But in many instances, it's also the political class that haven't stepped up and engaged in issues and engaged perhaps with the Charter and even engaged with the Constitution in a purposeful enough way. So that's sort of the nuance I want to provide you. But rather than talk about this scary specter of judicial supremacy, I prefer to talk about the concept of constitutional supremacy. Because I think if you rejig the debate and the discussion around constitutional supremacy, you're right away prioritizing and I think elevating this idea of the Constitution being supreme to all things in a way that elevates in a way that makes all of our institutions, other than the judiciary, but including the judiciary, obviously, and our citizenry, necessarily obliged to be engaged in this important concept. And to the extent that you're not engaged in this idea of the Constitution, which I just finished describing as being supreme, you're in some way abdicating or in some way impoverishing your involvement either as an important institution, whether it's Parliament, legislative, executive branch, or whether it be some of the tertiary institutions in society, in civil society, churches, the media, families, we as citizens. So that concept, I think, triggers necessarily an analysis and a perspective that I think makes it necessary to say it's not just the judiciary that should be interested in the Constitution. And it's not just the judiciary who should be engaged in the Constitution. Yes, they may, and we'll get into this in a second, be the final word, although that's a controversial proposition for many. It does, this concept of constitutional supremacy that I say is a more interesting prism through which to see this, it does force suddenly a re-engagement or a first engagement, if people haven't been engaged in the first place, with constitutional matters that unfortunately in the last, I'd say 15 to 20 years have been left largely to the courts. I think that's starting to change. The other issue that is interesting when it comes to focusing only on this idea of judicial supremacy is it kind of creates a false debate around a very simple question. Who gets the final word? Is it the judiciary or is it the legislative or executive branches? I don't like to discuss things that way because I'm afraid in most instances the answer will probably turn to the judiciary because of Section 52 of the Constitution and because there's, I think, a cogent argument for saying, look, if the notwithstanding clause is in the Constitution, one could argue that it is there because there was an assumption that the interpretation of the Constitution might lead to situations where the executive and legislative branches would require the invocation of the notwithstanding clause. I don't think that's a very productive debate to have, even if it's possible to say that the judiciary does, in most cases, have the final word. In some cases, it's not always the wisest decision that the judiciary comes up with. And I always like the proposition that just because a law is determined to be unconstitutional, it doesn't mean that the courts or the judiciary is necessarily making the wise policy choice. They're making a determination on the basis of some pretty sterile tests that relate to constitutional law. But what I'm trying to say in this long-winded kind of rambling answer is that the courts have an important role in interpreting the Constitution. They have an important role in interpreting the Charter. And they have, as a result, an undeniable new influence since 1982 on public policy and on important moral and social issues. There's no denying that. One can describe how that came to be. One can describe the extent to which perhaps the political class abdicated somewhat during that period of time. But the reality is the judiciary does have this increasingly important role. So the question that I ask myself is, how does, outside of the courts, outside of the judiciary, how does the Constitution become engaged with in new ways by, for example, politicians, by citizens like yourself in ways that don't necessarily involve you being litigants? And how does the media and other institutions in society do that? Because I think it would be an impoverished Canadian society if the only individuals who sort of had the sophisticated and sort of insider knowledge of the Constitution or the Charter was the judiciary. I don't think that's nourishing democratic ideas, democratic values, or the precepts that I think a healthy constitution like a democracy like Canada wants to have. In saying that, I'm not criticizing the judiciary. I can criticize the judiciary from time to time. I have my own opinions about some judgments, but they are doing what they believe they're supposed to do as guardians of the Constitution. But if there's not room outside of the courts, separate from the judiciary, to engage with the Constitution, we are setting up a Canadian liberal democracy that's leaving all constitutional dialogue, constitutional discussion to the courts. And that's not a good thing, because when you're discussing important issues that animate a polity like Canada's, you're talking about issues that civic involvement, I think, requires debate about. And if the courts are the only animators of policy emanating from constitutional discussions, then that debate will be dominated by technical and complicated legal formulations, juridical formulations, which suddenly, disenfranchises a lot of Canadians from discussing important matters on important policy issues, like, for example, assisted suicide. You have the list. You could go down I'm not talking about whether the Supreme Court of Canada was right or wrong on any of these issues, but what I am saying is there's got to be a capacity to have a way of discussing these matters outside and separate from legal juridical language. Otherwise, frankly, we lose the beat. We lose the democratic beat. And that's not a healthy thing. And this could go into other areas too. We lose our interest in political parties. We lose our interest in politics. That's not a good thing either. So when I talk about the issue of a potentially dominant judiciary, I'm not talking about it in the scary sense that the judiciary is always supreme and they're oppressive, despotic. Some people may see it that way. That's not my view. My view is, to the extent that this discussion sometimes involves this idea of judicial supremacy, it means, in my view, that we have to be cognizant of a requirement for balance and a requirement to have other players involved in this discussion and not just the judiciary.
Is it fair to say that with your idea of constitutional supremacy, that there's a kind of built into that is, it sounds like built into your view, is some idea of constitutional accountability, that there's accountability for the Constitution and needs to be outside of the judicial branch, in the political branches. And in some ways, what you're saying is that judicial supremacy is partly about the judiciary kind of not usurping the role of the legislature, but sort of filling a gap where that accountability is not being taken up much.
That's right. Well, there's no question. I mean, judges love to say that we didn't necessarily want to go here, when there's been, for example, an absence of legislation or a void or a problem with legislation, but the legislative branch or the executive branch was too passive or too timid. And in many cases, that's true. So in that sense, Professor Sigalet, that's exactly what's happening. But what I'm on about is maybe something even a little bit more subtle. I'm trying to create a constitutional culture where everybody, including politicians, understands that even in the era of the Charter, there's still room to be proactive and purposeful in trying to define and promote rights in legislation and mindful of rights in legislation in a way that I'm not sure always happens. And that's a problem. But that extends again to discussions in the ordinary course of a citizen's life. So that's why I say, if this discussion and if this subject of constitutionalism is left entirely to lawyers or to judges, the values that undergird our democracy will be not sufficiently nourished. And we're going to be educating and developing a new citizenry that will effectively be comfortable deferring this discussion and this focus entirely with lawyers and judges. And that's not a good thing for the important policy debates that have to happen. Wherever you lie, wherever you fall on whatever issue, whether you're left or right, I just want to see a citizenry engaged. I want to see a government engaged. I want to see the tertiary institutions of society engaged. And I'm not saying that isn't happening now, but I don't think it's happening enough. I think there's sometimes too much deference to the judiciary and the legal profession, which isn't to say they're rolling over and paying debt. I'm not saying they shouldn't be deferring to court orders, but if they're not engaged in that active participatory way, that's a form of deference that I don't think is healthy. And if I'm not clear on that point, I want some of you to challenge me or maybe ask me about it, because it's a critical point that I try to make when I talk about this potential imbalance.
So you already mentioned Section 33 and Section 52, the notwithstanding clause and the supremacy clause, respectively, of the Constitution Act 1982. But do you want to say a bit more about what parts of the Constitution, written and unwritten, and sort of help ground legally even your view of the importance of the Constitution outside the courts?
Well, look, at Section 52 and 24(1) are what they call sections that the remedial sections. I mean, they provide a basis by which judges can determine the invalidity of constitutional law based on the constitutionality of that law, and then they can, as a result, provide remedies. But Section 33, for example, is a section that is under a lot of debate now because of the case that's coming to Quebec. So I don't want to say too much about it. But Section 33, in many respects, is both a tangible and a metaphorical tool that suggests that the legislative and executive branches have a role to play, where, for example, they believe courts have made a determination or weighed in on something where the politicians believe a different view is required. And that's not necessarily part of a dialogue. It's actually a response, full-blown response to something that they want to override that the courts have done. So there's clearly a mechanism in the charter that permits a response from government. How that operates, we'll find out. The Supreme Court of Canada is going to pronounce upon it. So that's probably the most obvious way the framers have suggested that there's got to be some role left for the courts, for the legislative and executive branch when it comes to court determinations of invalidity. But when you look at the complexity of the charter, and you look at the complexity of the rights, both individual and collective rights that are protected, and you look at the communitarian nature of the charter, you have to believe that there is a role for the complex and, again, representative nature of a government to weigh in and express their own views through policy about what it is that, for example, a particular right in the charter might mean, its scope and its true essence. And it's a pity that in many instances government leave that first interpretation to the courts. They don't proactively and more purposefully sort of scope out what a right might mean based upon what they can properly discern is the purpose of a substantive right. So that's also, I think, a point that I think is oftentimes underemphasized and underappreciated. I'm not sure if that's answering your question.
That's definitely answering my question. But let's put some even more meat on the bones a bit and talk about your pre-judicial life a bit. So I already mentioned that you were the Crown's attorney in the Sauvé case, in the trial level and the appellate level, right? So in Sauvé, the Sauvé 1 was initially a challenge to blanket restrictions on prisoners voting in federal law, and that was struck down as a disproportionate restriction by an initial Supreme Court decision we call Sauvé 1, and then Parliament responds by introducing a new set of restrictions that are less onerous and only apply to those imprisoned for, was it more than 3 years?
2 years.
It's more than 2 years. Yeah, so it's 2 years or more. And with the expectation that this might uphold the court's reasoning in Sauvé 1 is relatively meager, not meager, we'd say. It's not very long. And so it's possible Parliament is expecting the court to uphold this more restricted restriction on prisoner enfranchisement, and or this more restricted disenfranchisement. And then you were the attorney defending that law, the response, right?
So the government of Canada in it was 1994, I was trial counsel, launched with another lawyer a defense of the legislation that was being challenged as a violation of Section 3 and Section 15. One of the Section 15 arguments was that prisoners are disproportionately Indigenous Canadians. That's certainly a fact. And that they were disproportionately affected before there's a violation of Section 15. Let's just put that argument aside. Concentrate strictly on the fundamental freedom of respecting the right to vote. That's where the principal focus was at trial and even on appeal with respect to evidence. Let me just sort of flesh out a little bit what Professor Sigalet said in terms of the background. The second piece of legislation stipulated that prisoners serving 2 years or more could not vote. It wasn't a lifetime ban. It was just prisoners serving 2 years or more. And once they were released, it was understood, and we argued they would get their right to vote back. Understand this, because evidence was adduced. This was a fascinating case to put together, because the evidence we had was fascinating. Evidence of sociologists, evidence of political theorists, evidence of a cultural theorist. There was
so that's Seymour Martin Lipset.
Seymour Martin. There was Thomas Pangle, Christopher Manfredi. There was a political scientist. There was a fellow from the States that we called, and many other individuals who filled in different parts of this. But on the piece of legislation, because this is important background to understand, 2 years or more, prisoners serving 2 years or more, are those prisoners who the statistics showed were the worst offenders. They had, on average, still recall this distinctly, back then, 28 and a half convictions on their record. Also, serving 2 years, these are individuals who would have been convicted for the worst offenses for the most part, right? Certainly serious property offenses, crimes of violence, and in some cases, murder. So we're talking about a category of prisoner who wasn't sort of randomly or arbitrarily stuck into a category of disenfranchisement because of the failure to pay parking tickets, for example, right? These were a purposely demarcated group who represented what the politicians, I think, believed were individuals who, in a foundational way, violated the social contract. So that's the background, that's the reference point. So we weren't defending or weren't arguing the case on the basis of Section 3 and whether or not Section 3 contemplated whether or not individuals serving 2 years or more who had the background that I just explained should have the right to vote, because we had to concede that. Government made the determination that based on Sauvé 1, that issue was dead. Now we were into proving that this was a limit, and it clearly was a limit on the right to vote, insofar as it prevented prisoners from voting, that could be justified as reasonable in a free and democratic society. So that was the defense. So it was on the basis of that defense that we had to deduce all of the evidence that I just talked about. So we talked, Professor Sigalet and I were talking earlier today, we adduced evidence from a well-known writer and scholar, Seymour Martin Lipset, who wrote a book called The Continental Divide. He's an American, but he was an expert on Canadian political culture. He talked about how Canadian political culture was a mix of a dominant liberal strain in the theoretical sense, in the philosophic sense, but with a very heavy tinge of communitarian and social democratic thought and influence. And that we had a conception of the free and democratic society that was more more communitarian. And we understood, for example, in different ways, the need to do those things that nourished and perhaps fostered a recognition and affirmation of community and order in ways that the Americans didn't, who had a more kind of classical, liberal approach to their polity. So that was meant to sort of define and to put in place a conception of what Canada's free and democratic society was all about. And we had other experts who talked about the pressing and substantial objectives that we had to adduce, obviously, as a Section 1 defense. So one of them was the cultivation and fostering of civic duty and responsibility, and that a law like this sends a signal to the citizenry that, look, if you're the type of category that has, on average, 28 convictions, and you're convicted for the worst offenses, you're probably not representative of the type of democratic values and the type of civic obligation and sense of responsibility that we believe while you're serving that penitentiary time, and this is penitentiary time, who deserves the right to vote. So that's the background to the case. It's in that context that the evidence was led. And to make a long story short, it went to the Court of Appeal, and it ultimately went to the Supreme Court of Canada. The government lost. The law was struck down 5-4 in the Supreme Court of Canada. Writing for the majority was Chief Justice McLaughlin. Writing for the dissent was Justice Glenn Joyal. Interesting, I believe when you read those two judgments, the dissent reads like the majority judgment, and the majority judgment reads like the dissent. Suggests that somebody at the last minute shifted sides, which is perfectly legitimate, but that's, I think, what happened. So if you ever want to go back and read an interesting judgment, go back and read that case. Read both the trial, appellate, and the Supreme Court judgment. But it's interesting to read the Supreme Court judgment because it reads, as I say, like a dissent or a minority judgment initially. The dissent is much more robust. Goes back to the foundational points that we tried to have discussed and canvassed at both the trial and at the appellate levels.
I was just saying, if you take Poly 431, the Canadian Constitution, Charter Rights and Freedoms with me, you will read that case. And but on the case, just to say a little more about and relate it to our topic of the Constitution outside the courts, one aspect of the case involves some commentary on Section 33 and the relationship of Section 33 to constitutional responsibility. So Chief Justice McLaughlin argues that the fact that Section 3 is not covered by Section 33, the fact that Parliament could not enact a law with Section 33 immunizing it from further judicial review, would mean that she should be more aggressive and the court should be more aggressive in protecting the rights under Section 3. And obviously that view is disputed by a lot of scholars, including Professor Manfredi, in some of the scholarship after that. What do you think about that, and how does Sauvé and the structural questions about Parliament's relationship with the courts, how does Sauvé speak to that change and the changes we've undergone? Because Parliament in this case actually did try to take up constitutional responsibility, tried to say it disagreed with the court about the charter rights in question, about these really important rights.
Yeah, I mean, this is not meant to be a personal criticism of the judges who are on that case, but it was a disappointing case for me anyway, for three reasons. The first, let's come back to your first point. I'm not sure that it's a cogent argument or a sufficiently determinative argument to say that because Section 3 is otherwise excluded from application in this context, that it's a case that necessarily requires a more aggressive or a more preemptive approach by the court. Otherwise, Section 1 defenses could never be launched in cases where government concedes that there is a breach. There was a breach in a case where Section 33 can't apply, but nonetheless, we think we have compelling Section 1 evidence based on our pressing substantial objectives and the evidence we used for them. So it was disappointing to have that type of rationale seemingly triumph, because it's a factor to consider, but it shouldn't be, I think, a dominant or even, as I say, determinative in the reason. The second reason I think it was a disappointing case is it really did, in many respects, for many people, including Professor Manfredi, who testified in the case, it did truly represent, in some respects, the death of dialogue, the theory that at that time was gaining some momentum. I'm not suggesting it doesn't exist, but I think there's a lot of cynics and skeptics right now who ask themselves to what extent it really does exist. That doesn't mean the Supreme Court of Canada is getting it wrong, or the Parliament or the legislative branches generally are not participating, but dialogue as a thing is not as not as focused upon, and is not as I think robustly invoked as often as it used to be as a conceptual idea that mitigates potentially an imbalance between the judicial and other branches. And this really was, as you said, Professor Sigalet, a case where Parliament was responding in a very purposeful, very measured and focused way with new legislation that responded to the criticisms in the first instance. The first Sauvé law was a little bit random, it was a bit arbitrary, and it was, in some instances, susceptible to the criticisms that individuals who were enveloped in the restriction or the constraint on the right to vote could be individuals who, for example, didn't pay their parking ticket and they were convicted and they were in jail. And perhaps they were in jail because they couldn't pay the parking ticket for socioeconomic reasons, for example, right? So you can understand the rationale in that first case. But again, I'm kind of reinforcing and underscoring what I said earlier on. In Sauvé 2, you're talking about a category of prisoner who had on average, and this is what the statistics showed, 28 and a half convictions. And they were convicted for the most serious of offenses. So that response, again, which was in some respects very representative and very indicative of the sort of dialogue that the court suggested they welcomed, did not succeed in this case. Finally, I'm disappointed when I look back at Sauvé because the majority judgment almost suggests, and maybe it does at one point expressly say, that the empirical evidence that we advanced wasn't sufficient to provide and substantiate sufficient proof to defend the normative objectives, particularly the first objective that we had, which was the idea of this law being an affirmation of an idea that fostered and cultivated civic responsibility and the rule of law. It's very difficult to provide empirical evidence that will establish in a sufficient way a normative proposition. But if there was ever a case where I think it was done, it was in this case. But it would be a sad thing to think, and I'm not saying this because I know I have friends on the Supreme Court who disagree with me, but it would be a sad thing to suggest, as I sometimes do, that normative, pressing, and substantial objectives are difficult on their own to sustain when you're arguing a Section 1 defense. The court increasingly looks to some type of empirical evidence that should exist. So I found that a bit discouraging in Sauvé, because Sauvé was in so many instances an interesting case study for dialogue, for the significance and relevance of the section being immunized from Section 33. And then finally, for this idea that normative, pressing, and substantive objectives can still be a compelling justification in a Section 1 defense. So for those who are interested in how the jurisprudence has evolved in cases of Section 1 and in normative sort of cases that are infused with interesting ideas of political theory, Sauvé was a bit of a disappointment.
I say, even though it's a disappointment, it remains very rich as a teaching tool or a window into thinking about some of these fundamental problems. And another aspect of it that just occurred to me that we may be worth talking about is this Section 1 issue where you were forced to defend the law, almost assuming an infringement under Section 1 and trying to prove that it was justifiable. But that way of talking, Section 1 doesn't speak about infringements. It talks about limits on rights. But the limit of something doesn't need to be an infringement of it. It can just be about the boundary and nature of the thing, right? So in subsequent litigation after post-Sauvé 2, other voting restriction cases have used the Sauvé 1 holding to then challenge restrictions on voting for expatriates, so Canadians living abroad, or voting for underage voting for those who are 16, and said, okay, well, if a citizenship is the primary grounds of having a right to vote, and any restriction on the right to have a vote to citizens have a right to vote, then surely not allowing someone living abroad who's lived outside of Canada for, let's say, like more than 5 years, surely that's an infringement of that right. Well, in this case, in the expatriate voting case of Frank, the court actually very strongly divided on how to best approach the Section 1 analysis, and even specifically divided on whether to consider those kinds of things prima facie infringements, or to consider some kinds of aspects of the right to vote as needing specification, because the right to vote needs an electoral system. It needs rules about how and when you vote and who can vote. And parts of those are not going to be restrictions on the right to vote. They're just going to be part and parcel of the way we structure and understand the right to vote. And the court, again, kind of came down on the side of everything that is not just about citizenship is a restriction or an infringement of the kind that the government has to defend. How much is that just a recurring problem, or was that at the heart of what you faced in Sauvé?
Well, it's a long time ago. Hearing subsequent account of what's happened since then just reminds me how Section 3 jurisprudence, has been deprived of the type of robust and full and I think nourishing analysis that it deserved. Because even even Sauvé 1, so I've been up since 3 this morning, even Sauvé 1 didn't really, I think, grapple with the scope of Section 3 in the way that you're suggesting it could have grappled with it, so as to assist with an analysis or guideposts or beacon lights in relation to subsequent issues that surrounded Section 3. So what happened? We're stuck now with the limits of the analysis in Sauvé 1. We're stuck with the concession made in Sauvé 2. And all we're left with, I'm being a little bit too, I think, opportunistic in my analysis here when I say this, but we're left now with this stark idea that the right to vote, understandably, but maybe without the type of background analysis that we would have liked, is sanctified in a fashion that just preempts any justifiable discussion about what the actual right contains in terms of its relational rights and responsibilities. So it's one thing to look at the infringements on Section 3 in a Section 1 defense, using that sometimes complicated and sterile test, coming from Oakes, for those of you who've read that case. But it's a more interesting analysis, in my view, to discuss and analyze how Section 3 in the right to vote has inherent in it certain limitations, certain relational obligations, certain inhibitions that speak to the issue of citizenry and civic involvement, civic obligation, and the whole notion of the social contract, right? I don't think, and one of the things we did in our case, we had, Christopher Manfredi, Professor Manfredi, who talked about, in some respects, the social contract as being one basis for arguing against the right to vote for these prisoners, because there was a breach of the social contract. But we also, in relation to the first objective, this normative objective of encouraging and fostering civic involvement and respect for the rule of law, we also had evidence that was more Aristotelian or classical, which talked about, the idea that we are also fostering in our citizenry good qualities, virtues, a way of looking at their involvement vis-a-vis their fellow citizens. Now, we were called at the time, our arguments were derided and sort of criticized as being virtue enforcing, right? We were trying to enforce virtue. Well, I guess you could call it that, but that's kind of sad to think that something as basic as instilling and fostering civic responsibility, even if it was connected in some ways to an Aristotelian ideal, that that's sort of off base, and that you need to rely on this sort of more modern idea of social contract. So my point is simply, all of that interesting discussion would have taken place in a much more productive and nourishing, I think, helpful way, not only in Sauvé too, but also in the subsequent jurisprudence that you've talked about. Now we're left with this kind of artificial, I think, impoverished discussion that still deals with the issue. The court takes the right to vote very seriously, and they're not being shorthanded about it. But I just don't think there's enough jurisprudence that actually went into the substantive right that I think could have assisted and maybe made subsequent cases, the progeny of Sauvé too, more interesting and more helpful for politicians, for example, when they're anticipating what is the scope of Section 3 and where can we demarcate rights? Where can we demarcate certain restrictions?
Is that dissent in Frank something of a guide in this regard for looking? Because what I like about the dissent in Frank by Justices Cote and Brown, then Justice Brown, is that it draws on scholarship of guys like Gregoire Weber and Richard Eakins and Justice Miller on the Ontario Court of Appeal, formerly Professor Miller, to say that things like the Westminster system of government require certain rules particular to the Westminster system of government that involve voting in a riding for a particular MP. And that means not voting on an abstract ballot for the Prime Minister. And I just think it's actually there's a little bit of funny stuff in the press a little while ago where Pierre Poilievre is running, the current Conservative leader is running, saying to vote for him for Prime Minister. And all of these commentators are scolding him, saying, no one votes for the Prime Minister, Mr. They vote for the MP. And it's like, oh, well, if they don't vote for the Prime Minister, they must vote for an MP. How is it that you're voting from across the ocean for your local riding's MP? Like, the connection between those things is true. You are voting for your MP to vote for your Prime Minister indirectly. They're both right in a way. But on the true technicality, the system is built for you to vote in this particular way.
You're quite right. I mean, Frank, quite right to raise Frank, because Frank was the dissent in Frank. It was trying to grapple with this idea of what is the scope of Section 3, and are there inherent sort of relational component parts that require us to look at duties and responsibilities simultaneously. And it was very interesting. I did prevail because it was for dissent in the end, but I thought it was a really interesting analysis, and I think it was an analysis that probably was deprived of daylighting in Sauvé too.
Well, we want to ask you to comment on working families, which is another Section 3 case that just came out last week. But all of our students are welcome to Google it after class and maybe think about some of the things we're just talking about now with Sauvé and think about it. Or my classroom, we can talk about it. How much do you think that legal education in Canada, both legal education in political science classrooms and undergraduates, or God forbid, sociology classrooms, I won't apologize for saying that actually. Or in law schools, how much are they kind of complicit in the descent into this sort of charter focused and particularly judge focused constitutional culture that we have now?
Well, okay, part of it's understandable. Again, my criticism isn't the fact that in law schools or even in science departments, I want to tip my hat to political science departments in a moment, or even in a sociology faculty, that they're studying.
Don't say that.
I'm pandering. That they're looking at charter jurisprudence it's important that that be done, whether it's being done descriptively or just pedagogically, to have some idea of what is now increasingly an important, influential, and sometimes dominant sort of strain of policy involvement or policy formulation. But your point, the point behind your question is exactly right. There is a limit to what it is that I think that's being offered, particularly in law schools. Again, it's logical that law schools would spend a lot of time when it comes to the charter on examining the jurisprudence and examining the tests that now exist with respect to substantive rights. It's understandable that that becomes the insight into how the charter works and how we might predict judges to, in the future, interpret the charter. The problem is we're examining the jurisprudence, and we're not necessarily examining the Constitution and the substantive rights or its sections, if you're talking outside the charter, in a way that takes the document on separate from what the judges are saying. That's part of what I'm on about. You have to respect what the judges are saying. They have a role. It's an important role. I'm not trying to criticize that, where I always agree or disagree, or whether people always agree with me or disagree. That's not my point. It's just that the educational component, as it relates to the charter and the Constitution, has to involve things outside of simply the examination of decisions and jurisprudence. For example, in law school, legal history is taught, but it's not taught like it used to be. The idea of political theory, which is at the root of so much foundational charter jurisprudence, is not studied in law school either as jurisprudence, which is a kind of a political theory version in the law school context of what I'm on about, political theory, nor is, for example, the institutional relationship of government branches and the judiciary examined. So you've heard me speak now for the last 45 minutes about what I think is the challenges of the Canadian polity. If none of that is being sort of addressed in the way that I suggest should be, it means that it's not surprising in some ways that the constitutional culture, as I'm envisioning it, you'd say that's the world according to Glenn Joyal. Well, that's my take on it. I think there is an absence of a more robust discussion, partly because of the way law is taught, certainly in law schools. The law schools have to teach subjects, and law schools are doing a good job certainly teaching the charter, and in some cases constitutional law, but it's constitutional law from a particular perspective, and it's not necessarily as informed by constitutional history, Canada's constitutional history. The division of powers is not really taught like it used to be. Political theory is not part of that education. So for me right now, the most interesting discussions when it comes to the broader discussion of the Constitution in a constitutional culture in Canada's constitutional liberal democracy is coming from the political science departments. Not because it's a critical theory or a critical kind of perspective on the courts, but just because it seems to be a more broad-based, it's a more interdisciplinary approach to this important subject. And it seems to better grasp the sweep of the subject. And law professors are very bright people. Law students are very bright people. But it's odd and maybe a bit incongruous that when they're talking about the Constitution and they're talking about the Charter, most of their discussion comes from the way they're being taught, which is in many respects about the Charter and Charter sections through the jurisprudence and the jurisprudence alone. Clearly, that's part of it. You can't ignore the jurisprudence when it comes to looking at the Charter. But there doesn't seem to be any independent discussion about the sections, the purpose of the sections, when they were first formulated, and how that might relate to the interesting events surrounding 1982, for example, or Canada's legal history more generally. And it's certainly not a perspective that's interdisciplinary. So I think that's too bad. So that's why I say the way law is taught is perhaps a bit more myopic in law schools, ironically enough, than in political science departments.
Yeah, that's interesting. And I mean, initially, some study of law and political science were closely linked in historically. Yes. Like the University of Victoria's law school was a political science and law school at the beginning. And
but I'm an institutionalist, and I value and I'm loyal to my institution, which is the judiciary. It's housed by good people, even if they don't always agree, even if I don't always agree with them. But institutions are important. They really are important for reasons that I could spend the next half hour talking about. But if that's the case, how can you not examine my institution in relation to other institutions? I mean, the polity of Canadian society, properly understood, has to involve that broader discussion, that broader examination. And as I say, it's the only way to get this proper sweep of what it is that these institutions can and I think have to do. So I hate to use the word silos because it's kind of a cliche, but we do tend to teach constitutional law in ways that are very reflective of academic silos, and that's not helpful.
So it's also fair to say that the law schools aren't just teaching the case method and focusing just on that. They're also doing it in a particular way where they're focusing on policy and usually with a kind of critical theory lens that isn't often informed by a kind of empirical analysis political scientists conduct, right?
So that's one of the criticisms.
Yeah.
That's one of the criticisms. I think there's a greater balance now. I'd like to view it as a greater balance. There's an increasing diversity, I think, in law schools now with respect to how law is taught. I find that encouraging. I'd just like to see the subject, when it comes to subject of constitutional law, examined in a slightly more broad and expansive way I described it. And some law schools might, if they were watching this, they might say, well, wait a minute, I'm in the university of so-and-so, our faculty has done this, how can you say? Maybe that's so, but if they're doing it, it's not clear to me. It's not obvious.
Yeah. So we talk about all of these problems with the other branches not taking up responsibility and with legal education, perhaps contributing to that on the bench too. But so let's say a enlightened justice, and by the way, now you're in the running for political scientists' favorite judge because when Justice Rowe was here, I said he was strongly in contender for that because he worked in politics and actually reads political scientists and regularly says nice things about us. So now you're in good company.
Academics are so easy to flatter.
Yeah, exactly. Yeah, we welcome the flattery because we don't get enough of it now. But what, like let's say you're this enlightened judge that reads political scientists and not sociologists, and you want to affect the other branches and have them take responsibility. Like, what can you do? Like, what is the role for the courts in mitigating these problems, given that they seem to be exogenous to the judiciary, at least partly, and not all the fault of courts necessarily?
Well, judges speak through judgments, reasons. And so if they're involved in an adjudicative context, matter, constitutional challenge or otherwise, you hopefully write reasons that are mindful of what it is that you believe in as an institution. Now, it's got to be governed by the law. That set of reasons or that rationale that I might offer up in a given situation has to fit within the governing law, but it can invoke, for example, component parts to an argument that are institutionalist, that underscore maybe for someone who's unfamiliar or perhaps who's never sort of seen the emphasis placed upon this institutionalistic approach. You can introduce it for the first time. So that's important. But separate from that, so judges can do that in their reasons, if and where appropriate. They don't, they don't simply go out and start spouting off about, themselves or their role as institutionalists. In a particular context, their reasons will reflect. It's like a playwright. You don't go out with a message, but your message presumably comes organically from the play and the actions of the play. Similarly, when you're writing reasons, if you're a judge, your approach as an institutionalist, looking for the type of balance that I've talked about and that Professor Sigalet's been asking me about, will come from reasons in different contexts. You see it with Justice Rowe. I hope people see it when I write in constitutional cases that I've been involved in, or even non-constitutional cases. So that's the adjudicative potential that a judge has, whether you're on a trial court, whether you're in a court of appeal, or whether you're on the Supreme Court of Canada. But separate and apart from that, I think there is, and we'll get to this in a moment when we talk about, judicial independence and the obligation on judges, despite the ethical cautions that have to be, I think, exercised. There is an increasing obligation on the part, particularly of chief justices or engaged judges in areas of public law, to speak out in ways that provide, I think, important public information about the institutional role of the judiciary, explain what it is we do, why it is we do, where it fits, and why, and this is where it gets maybe in some cases a bit provocative, how it has to be made to reconcile with this institutional or institutionalist perspective, and how we have to ourselves exercise some humility and some modesty, but at the same time take our place as guardians of the Constitution in a context where there exist other institutions who should be or can be engaged in a constitutional discussion in a constitutional culture. So outreach, what I'm doing now, and you hear the themes I'm touching upon. By the end of it, you may have a headache, but you'll walk away at least with some sense of what I'm trying to say and what certain members of the judiciary are trying to say. We're not in any way abdicating our role. I'm not abdicating